Hey y'all, I'm the Loud Little Ducky. Today we are going over a filing that Cory Keith put out. This is an older filing, but this is the first time we have seen it. This was submitted as an exhibit in part of Chingris's bar complaint to try to show his defense on the medical aspect of things. We will be putting out the video for that tomorrow, but I wanted to go over this first so we have all the context. So this is Owens wants privacy and protection, the confidentiality and protective order in the Owens v. Echard case. We have filed on January 17th, 2024, motion for confidentiality and preliminary protective order assigned to the Honorable Judge Julie Mata in the Owens v. Echard case in the County of Maricopa Superior Court of the state of Arizona. Petitioner Owens herein, petitioner by and through undersigned counsel hereby files a motion for confidentiality and preliminary protective order pursuant to Rule 53, Arizona Rules of Family Law Procedure. Petitioner requests the court sign and adopt the proposed protective order attached hereto as Exhibit 1 or Exhibit I as formal order of this court to issue its own protective order as deemed suitable by the court. Number 1, statement of facts. 1. On August 1st, 2023, petitioner filed her petition to establish paternity, legal decision-making, parenting time, and child support herein after the petition. Number 2. On August 21st, 2023, respondent filed his response to the petition. On December 28th, 2023, petitioner filed a motion to dismiss, requesting that the court dismiss the petition. On January 4th, 2024, respondent issued notice of deposition summoning her to attend a deposition scheduled for January 17th, 2024, which is also the date he filed this. She was supposed to sit for a deposition. On January 11th, 2024, undersigned counsel filed this notice of appearance on behalf of petitioner. On January 16th, undersigned counsel emailed legal counsel representing respondent opposing counsel, asking if respondent would agree to a preliminary protective order with relation to the deposition. Respondent declined. See Exhibit 2, which we've seen the emails where Woodnick would not agree to that. Alright, so 2, law and argument. Rule 53A of the Arizona Rules of Family Law Procedure allow the court for good cause to enter an order to protect a party or person from annoyance, embarrassment, oppression, or undue burden or expense, including one or more of the following. She brings her own embarrassment. She's an annoyance to everybody. She's not oppressed, even if she would try to say she is. But anyways. 1, forbidding the discovery. 2, specifying terms and conditions, including time and place for the discovery. 3, prescribing a discovery method other than the one selected by the party seeking discovery. 4, forbidden inquiry into certain matters or limiting the scope of discovery to certain matters. 5, designating the persons who may be present while the discovery is conducted. And he's going to go on with more. 6, requiring that the deposition be sealed and opened only on court order. 7, requiring that a trade secret or other confidential research, development, or commercial information not be revealed or be revealed only in a specified way. And 8, requiring that parties simultaneously file specified documents or information in sealed envelopes to be opened as the court directs. So he doesn't want any of this information out there, because it's not good that the information that's out there is already out there. He doesn't want any more. And Owens is blaming it on Clayton. And Cory Keith later finds out it's all her. Furthermore, Rule 53D also allows the court to enter an order that limits a party from disclosing information or materials produced in the action to a person who is not a party to the action. A. The party seeking confidentiality must show why confidential order should be entered or continued, and B. The party opposed confidential must show why a confidentiality order should be denied in whole or in part, modified or vacated. The burden of showing good cause for an order remains with the party seeking the confidentiality. So he wants everything confidential and on the hush-hush. He does not want the public to see it. Because Owens has said that it is Clayton leaking it when it was in fact her that was leaking it. Additionally, Rule 53(2) requires that the court make finding of fact concerning any relevant factors, including but not limited to A. Any person or persons needed to maintain the confidentiality of such information or materials, B. Any non-party or interveners need to obtain access to such information or materials, and C. Any possible risk to the public health, safety, or financial welfare that a certain information or materials may relate to or reveal. Well, she should have thought about some of that before she did all this. Case law directly citing Rule 53 of the Arizona Rules of Family Law Procedure is sparse. However, as the commentary for Rule 53 states, Rule 53 is based on Rule 26C of the Arizona Rules of Civil Procedure, which provides additional insight and case law on the subject. Rule 26C 1 similarity provides that upon good cause shown, court may make various protective orders that justice requires to protect a party or persons from annoyance, embarrassment, oppression, or undue burden or expense. Rule 26C1 Arizona Rules of Civil Procedure, CEG Arperio versus Figueroa, which is an Arizona case from 2012, Macmillan v. Schwartz, Arizona Court of Appeals in 2011. Sorry if you hear my grandbaby screeching. He is just having a field day out there. The text of Rule 53A of Arizona Rules of Family Law Procedure provide the court with no fewer than 8 separate and non-inclusive means by which it might ensure that a party is not subjected to annoyance, embarrassment, oppression, or undue burden or expense. In other words, the rule provides the court with broad discretion in fashioning orders for parties or information entitled to protection. Petitioner's proposed protective order attached hereto and incorporated by reference, request, and relevant discoverable information, which either party designates as confidential, remains confidential and is not disseminated to anyone other than the parties and their respective counsel, including if any one party objects to the confidentiality designation and until signed designation is removed by the court. The protective order also seeks that any party deposition in this matter, if deemed appropriate by the court, are designated as confidential until either party requests that the court make an evaluation into whether parts of the deposition or the deposition in its entirety should have the confidential designation. That is very clear. You know, the court can decide whether things should be disseminated out into the public or not. I think the only reason that this was not agreed on was just the fact of public records and stuff like that. But in some cases, this might be something that's good. Certain information the public really shouldn't see. But when it's all put out there, not much you can do about it, especially when it's your client that's doing it. I think Cory Keith was right in trying to request that he was doing his job. 1. Respondent's request and anticipated discovery will further annoy, embarrass, or oppress petitioner. My question here is, why would it annoy or embarrass? It's not oppressing the petitioner. And that's because it will show that she's lying. And she didn't want everybody in the public to figure out that she was lying. She wanted to still be able to spin her narrative. And that's just not, I mean, it's not how things played out, but you don't get to keep your lies a secret when you come to court. You're airing your dirty laundry out when you go to court because we have open courts and public information. She just wanted to spin everything her way, and the judge didn't let her have her way for once. Respondent's anticipated discovery is sensitive in nature and should be protected. Respondent intends to depose petitioner or is seeking discovery related to several sensitive and potentially privileged topics, including her previous sexual relations, specifics regarding the sexual encounter with respondent, previous pregnancies, discussions surrounding potential adoption or abortions, her privileged medical records, her miscarriages, and other topics. Well, maybe she wouldn't be so embarrassed had she not been doing this for 10 years. Sorry, it stinks that you have this person as a client. But that she shouldn't have been running a scheme. While petitioner concedes that certain discovery may be necessary in this matter to appropriately litigate unresolved issues, including the issue of attorney's fees, this limited issue does not warrant the dissemination of sensitive information to non-parties to this case. And you know what would have happened if Cory Keith would have stayed on as her attorney, which he couldn't because he couldn't knowingly lie to the courts. But if he did stay on, all that medical stuff that was put out to the public and that Gingras just gave out there for free for everybody to analyze and find more lies, find the fiber, all of that stuff. If it would have been kept quiet and Gingras didn't put it all out there like that, none of that information would have been discovered. But Gingras let it all be discovered. Cory Keith would have kept everything private. And Clayton wasn't going to go out there and put it out there because he wasn't the one doing it in the first place. So a lot of stuff we would not know about if it wasn't for her current representation. Because he would have done it himself, kept things private, whether a ruling went in his favor or not. And Clayton wouldn't have done it anyways. So less would be known about this case, and maybe Owens wouldn't look as bad as she does now, because more was discovered. Let's continue on. Petitioner has already been annoyed, embarrassed, and oppressed by respondent's actions and has concerns that this will only worsen as discovery continues. Well, she wasn't wrong. She can be annoyed and embarrassed. I still don't see where she's oppressed. And things did worsen once everybody found out about certain things. That was because of her own actions, though. Respondent is consistently using his social media platform to control the narrative of this case. No, he's just speaking his truth. I don't agree with you there, Cory Keith. Respondent is an American television personality best known for his appearance on 2 seasons of Bachelor/Bachelorette. Respondent has approximately 360,000 social media followers across Instagram and TikTok alone. See Exhibit 3. Respondent has also made appearances on multiple interviews or podcasts through this case where he has discussed this case/situation. Okay. As a result, petitioner has been the subject of disparaging comments, harassment, annoyance, and undue scrutiny from tens of thousands of individuals online. See footnote 1. Well, it's because people found out about her lying. And you know what? He got disparaging comments, harassment, and was annoyed and had undue scrutiny from people online before the truth came out about her. This is why I hate in the Depp case too, is Amber Heard's like, woe is me, everybody's saying this stuff. Well, for 6 years prior to Amber Heard and all the evidence that came out about what she did, everybody was doing that to Depp for 6 years. And now she's like, well, everybody's mean to me now. Well, for 6 years, everybody believed you. So Owens, people believed her because who in their right mind is going to make up a pregnancy that is so easily to prove? But then it was found out that she lied and doesn't have any proof of ever being pregnant in 10 years. But footnote 1 says, counsel notes the specific instances of online disparaging of petitioner are not included in this motion, as counsel believes this would only encourage the conduct for the people following this case. To the extent that the court deems it appropriate or necessary, counsel will provide the court with specific instances of public comments which are annoying and embarrassing. Petitioner across social media and online platforms. However, any such disclosures should be protected under seal or revealed via in-camera review, which only the judge and attorneys present to avoid worsening the continued impact of this case to petitioner. And you know what? Props to him. He's not putting everything out there. Gingras just posts it all. He's like, I'll call out everybody. I'm going to put your social media tags on there. I'm going to attach these videos. I'm going to make a compilation CD for Judge Fisk. Cory Keith says we have these things, but we're not going to put them in there because then the JFC people are going to talk about it more and they'll be like, oh, I was put in a filing and so forth. Cory Keith didn't want more of that to go on, so he just was like, we have it. If somebody wants to see it, I'd be happy to submit it. This deliberate effort to shape public opinion has created an environment that is not only emotionally distressing for petitioner, but she created this emotionally distressing environment, but also poses a potential threat to fairness of legal proceedings. No, not if you have an unbiased judge. Petitioner desires to litigate this case, not kiss, nothing, on merits, free from ongoing concerns that she will receive further annoyance and embarrassment from the public should aspects of disclosure and her deposition testimony be freely disseminated to the public. While petitioner concedes that she also made comments to organizations, these efforts were an attempt to clear up the many false narratives circling publicity. She put the stuff out there and she created things. And it's not a false narrative. But you didn't know that at the time, Cory. 2. The court should limit the method of respondents' discovery abilities. The only issue remaining in this action is the issue of sanctions or attorney's fees. It is undisputed that the parties do not share a child in common and the petitioner is not presently pregnant. Because remember, this is after she announced that she had miscarriages, had a vanishing twin, lost the babies, whatnot. A deposition is necessary to seek information. Respondent would require to properly litigate the sole remaining issue of attorney's fees. Respondent refused to agree to enter any preliminary protective order prior, causing this necessity for filing this motion given respondent's mainstream history of divulging information related to the case to the masses. When was that done? Without assurance of protective order, petitioner anticipates portions of and/or her deposition as a whole will be discussed or disseminated publicly, thus subjecting her to additional annoyance or embarrassment. Footnote 2. Counsel notes that in his limited time on the case, substantial amounts of information have leaked to the public or media within hours or days of the information being transmitted. This includes not only things like motions, but also emails between counsel and other details surrounding the case as well. Well, Cory, those emails were put into motions and responses and things like that. That's how we know about them. Petitioner believes discovery can be completed sufficiently through alternative means, including the use of uniform and non-uniform interrogatories, the request for production of documents, a written deposition, cross-examination, or other means. 3. If the court does not preclude the parties from conducting depositions of the opposing parties, the court should limit the scope of the depositions to the present matter. In the event the court does not outright deny the parties' abilities to depose the other, the court should limit the depositions to the issues narrowly involved in the present litigation. Petitioner believes this should initiate with the parties' act or alleged act of sexual intercourse. In an email exchange between counsel, respondent counsel has expressed intent to depose petitioner regarding her previous relationships, which are entirely unrelated to this matter. Which they can be. Because just because she did things in another case doesn't mean she did it in this case. That is true. But when it becomes a pattern and there's no proof of her pregnancy and she's not willing to cough up the stuff, it kind of becomes relevant because it does show a pattern. At this time, though, Cory Keith did not know that Cory Keith thought in his mind that the reason that Owens wasn't showing him or giving him certain things for discovery was her hesitation of it getting out to the public. When in actuality, there was no discovery to be received. But Cory Keith didn't know that because this was before HIPAA things were signed and everything else. He thought that there was still information and stuff that was out there to prove his client was telling the truth. He just found out later that she wasn't. 4. The court should issue an order designating confidentiality, deemed discovery as protected and confidential. The present case is unique. This court is aware of constant struggle within Arizona courts and laws weighing the best interest of the child against the privileges designated to protect communications with certain professionals. While this case is still labeled as a family court case, the parties do not share a minor child in common, and therefore there is no obligation for petitioner to share protected or privileged information. Almost all the requested discovery to date seeks otherwise privileged information from petitioner. While petitioner concedes that the disclosure of certain medical records may become necessary to support her claims, she is uncomfortable disclosing such personal and private information without a protective order in place. Like I said, he was under the impression that she didn't want to share this info with anybody until it wouldn't be shared with the public. But that was not the case. Even then, petitioner should only be required to produce evidence establishing the viability of her claims instead of all medical records or HIPAA releases, as respondent has and will likely continue to request. 3. Conclusion. For the reasons set forth, issuance of protective order is necessary and can be accomplished without any material prejudice to either party. As such, petitioner asks this court to sign the proposed form of preliminary protective order attached hereas to Exhibit 1. Doing so will protect the parties from additional embarrassment and annoyance while allowing this case to be decided on the merits. And I don't necessarily disagree with that. Like, it could have been decided just on the merits alone. It wouldn't have gone in her favor. It would have still gone in Clayton's favor, going by the merits of the case. We just wouldn't have all the information that we have. So it's not a bad argument. And this was respectfully submitted on the 17th day of January, signed by the Valley Law Group, Cory Keith. And then it was sent to the correct people. So about a month and a half later, on February 21st, 2024, Judge Mata entered an order in the matter of Owens v. Echard that stated, the court has received and considered petitioner's motion for confidentiality and preliminary protective order filed on January 17th, 2024. Respondent's response/objection filed on January 19th, 2024, and petitioner's reply filed on January 31st, 2024. which we don't really have those. It is ordered denying petitioner's motion for confidentiality and preliminary protective order filed on January 17th, 2024. So that was Judge Mata's ruling. The order is denied to keep any of that confidential, and she's not signing a protective order. But then you have the hearing that states she still doesn't want other parties to be putting medical information out there. And the medical information wasn't being put out there, except for Gingras came in and started releasing it all to be like, here's what I filed today, here's what I'm going to file today, and it had all that information in it of his client, where Cory Keith was trying to protect his client and not having all of that stuff come out to the public. I think Cory was trying to do better by his client than Gingras does. Gingras doesn't care about anybody but himself. But let me know what you think about this order, and stay tuned tomorrow for the Arizona bar complaint information, where this is one of the exhibits Gingras uses to excuse his sending out Owens' medical information, because it was her medical information to give. Clayton just couldn't put it out there. So I will see you guys next time. Bye.